Earlier today, we were talking about the whole Sarah Boone situation live on stream. Now, as you guys may know, I'm sure all of you know, Sarah Boone wrote 5 motions to the judge. She was talking about it. A lot of it had to do with wanting standby counsel, and on top of that, being able to depose certain people. Now, I assumed the judge would allow her to have some standby counsel, but it turns out that the judge was pretty much like, nah, not gonna happen. You're by yourself and you know why you're by yourself. But we're gonna go step by step and break down these motions. Shout out to Lori Reese because she read these like 50 pages of motions. I was planning on doing it and I was dreading the fact that I had to, and she came in like an angel from heaven. So shout her out. I appreciate her. But without further ado, folks, we're gonna get into this thing. And I mean, save it for the evening, get the snacks or whatever, because this is a long one, and it is it is mental gymnastics.
Motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. They'll probably grant that. What she thinks that is and what that encompasses in terms of work product might be a surprise to Sarah.
Honestly, I read the response. I think I read the proper response, and they said the motion or the decision has been passed that she's not having any help at all. So that's been denied already. So that's kind of crazy.
Comes now, Sarah Boone, pro se indigent defendant, respectfully requests from the court immediate relief by providing effective standby counsel with all legal services allowed and included to assist and aid the defendant as a whole in the complex, vital procedural preparation with professional guidance during her forfeited right to counsel by the court.
Exactly, Boo. Boo, I see you. They did not grant it. So I thought they were going to, exactly what you said. I thought they were going to at least give her standby.
Say attorney, and in her proposed lawful representation of self in her criminal case. Defendant's justifiable reasons for requested relief and assistance are as follows. The defendant's sixth constitutional right to counsel is being violated, unlawfully withheld, and forcibly removed from the indigent defendant under false pretenses, speculation, libel, and misconstruction. By the defendant's lawful practice of her entitled first constitutional right to free speech and her God-given right to do so by writing her experience-derived truth and providing a red flag exposure in her correspondence to the court, requesting needed intervention to avoid present
Red flag exposure in her correspondence to the court. What the fuck does that mean? Is it's a red flag that the media is interested? You know what I'm saying? You said Sarah's tripping, huh? Man, listen, Sarah is big tripping out here. She puts all these words together like libel and what was misconstruction. Well, I don't even understand how that makes. She puts all these words together and it doesn't really make sense, bro. You could tell she's just reading out of that dictionary as hard as she can. But like, anyways, let's continue.
Circumstances, she has lost completely her ability and advantage to properly, rightfully, successfully prepare her defense of innocence, progressively advance fairly and unrestricted while having the ability to be leveled equally with the prosecution.
And she's entitled to her constitutional right to free speech. She is going to get her right to free speech. She's about to have so much free speech. Bro, she's about to have so much free speech right now. It's crazy. Don't you worry. Don't worry. Why would they put anyone else in the position of attack by Boone? At this point, you could tell she just attacks her counsel and she doesn't listen and she stalls. I cannot believe that they took 8 lawyers to do this. You know what I'm saying? I thought it was going to be a lot faster. To be honest, this is way overdue. I said this like shit, maybe more than 3 months ago. I was like, she's gonna go pro se because the lawyer that she gets, she's gonna get some lawyer. I mean, some judge that's not gonna be with the shit. It was either Kranick or it was gonna be another judge. Because Kranick was gonna go to eventually. We're gonna be on lawyer number 17, and then judge number 3 would have been like, you know what, bitch, you're representing yourself. That was always gonna happen. I always thought that curly hair Miss her last lawyer, I forgot her name. I always thought curly hair was gonna be her girl, like woman to woman. She's good with difficult clients. I always thought she was gonna be done with her, but after that, I knew she was gonna go pro se. I said that shit myself.
The defendant is not an officer of this court or any court or legal system as a whole. She is not bound lawfully under oath or certified in any professional means to be or act as a legal agent or representative, lacking requisite professional competency, experience, expertise in the field of law presently and historically. The defendant is presently incarcerated, which is causing and will cause unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities in and to her ability to complete tasks and timely responsibilities suitable to the vital defense of the defendant's life and livelihood futuristically.
It's like prolong as long as you can, right? Don't hate the game. Don't hate the player, hate the game. But when the player starts doing some dumb shit to the point where they fuck themselves over, it's kind of like, well, I guess the player's a fucking dumbass, ain't he? Kind of stupid, ain't it? You know what I'm saying? Like, come on now. What's up, fan lady? How you doing? They warned her about it. I feel like even the press warned her about it. She knew about it off of YouTube as well. Don't think she's not in there watching her little YouTube and whatnot. You know what I mean? Don't think she doesn't have a little phone that an inmate kind of took out of their asshole and kind of gave it to her and let her watch the news. You know what I'm saying? She's watching shit through the prison. 100%. She was warned. We warned her. If it wasn't me, it was another channel. There's a lot of channels covering this. If it wasn't any channels, it was her lawyers. If it wasn't the lawyers, it was the judge. I think even the judge had kind of like alluded to it in a hearing. So, anyways, kind of stupid. You have to just blame her at the end of the day.
By the court rejecting professional, educated, experienced aid and assistance of effective standby counsel to and for the defendant in preparation and production of her rightful defense, results may be adverse from the unfair, disadvantaged, oppressed circumstances to properly thrive in her forced position by the court of pro se attorney and representation of self. Examples of said unfair burden, limitations, deprivation, inaccessibilities, and unequal opportunities include: the defendant has not received from the court to date of this motion any of her promised discovery or case-related materials submitted by former attorney to the court during the unannounced hearing on 6/28/24. Unannounced, she's got to just throw these extra words in there to remind you that while it was a surprise hearing with only 4 days, oh, where's the count? 4 days to submit my demands and motions delegated by the court on or before 7/22/24. The defendant has not received from the court to date of this motion any of her promised discovery or case-related materials submitted by former attorney to the court during the unannounced hearing on 6/28/24. I thought I just read that. Oh, I did just read that. She wrote it twice. The defendant does not have access to a computer. She will now. And she'll also have all her disclosure. The defendant does.
I remember they responded to a lot of this stuff. She'll have her computer. So all this is locked in. All her motions. And then she was talking about having a detective. They gave her the detective ahead of time. So there's a few things that she was bitching about in this letter that she already has right now and they already were thinking about. So again, she's on hyper mode. I think she's going to settle in the closer the case comes to it, but she needs to have a grasp on what's happening. And right now, I know she doesn't know what the fuck's going on. There's so many things. There's so much paperwork. There's so many emotions in her brain. Yeah. Again, she's a dumbass for doing this, but I will say she's putting in a lot of effort. She's putting in, the type of effort you would expect someone to put in if their life, was on the line.
Does not have access to the internet. The defendant has extremely limited, irregular access to basic tablets supplied by OCCD. Well, that's all going to change, so that's no longer going to be a concern. Defendant has access to pay phones for collect calls only, limited to 15 minutes each call. It's going to be interesting how they deal with that. I don't know if they already have a system set up for pro se defendants from the place where she is being held. I don't know enough about that particular place and their protocols in order to really comment. But could you imagine Sarah having unlimited access to telephones? Defendant does not have access.
Listen, if we, man, this is Florida, man, I'm praying. I need those phone calls. I know we can't get them right now. I did a FOIA request for Sarah Boone a few months ago. You guys remember that? They gave me like 2-3 pages. I don't know if I just did it wrong, but they're basically like, fuck you, dude. I felt disrespected. I was like, damn, you're really going to give me 3 pages of shit that's online already? I felt mad disrespected. But anyway, I'm assuming after the trial is over, we're about to have a lot of Sarah Boone phone calls, folks. Holy shit. I'm excited, man. Like she said, imagine Sarah has unlimited access to the phone. Holy shit. You know what I'm saying? That would be crazy.
Access to organizational supplies or production equipment, copier, printer, etc. I could see that being necessary, and they may have to do something about that. But I think that for the necessary material, I think they'll have ways to work around that. They're not going to let her be printing off stuff and taking it to her cell, that's for sure. Well, I shouldn't say that's for sure. Defendant does not have access to a meeting.
Man, we need to make friends. Yo, if you guys got free time, go call up the jail, make friends with a guard, make friends with an administration staff, ask them how their kids are doing, and then when the time is right, strike. Ask for the fucking Sarah Boone documents because we need them. We're fiending for them. Can you imagine that? God damn, I'm ready. I'm so hyped up for this shit, folks. You guys don't even get it. You guys don't even.
Place for privacy in case review preparation. I think the court's going to address that. And as for, wait a minute, she says meeting place for privacy in meeting place. Who is she going to meet with? Because case review and preparation, she may need to meet with a standby. I don't even know if she needs to meet with somebody. Maybe the investigator. Additional daily obstructions and undetermined hardships, disadvantages, difficulties will likely come about due to being incarcerated. Yeah, they warned you about that. And once my case materials are finally received, continued application in reasoning and further lawful support of defendant's request for immediate relief with standby counsel to aid and assist in preparation of her criminal case. A. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime. Okay, she's quoting stuff. It's interesting here, though. She's citing, I'm not going to read all this stuff she's quoting. I'm not going to read you the legal dictionary's definition of things. But I do want to point out it's interesting that she brings up a right to a speedy trial in requesting standby counsel. It seems to me there's a different argument to be made here. However, she is citing this, so let's talk about that for a second. It has been pointed out to me repeatedly that she did not waive her right to a speedy trial, that somebody else waived it for her, or counsel waived it for her. While that may be true, it is Sarah who has caused many of the delays. Sarah, who has caused...
She can't get an appeal on that shit, bro. I know everybody's saying, oh, she could probably get an appeal on that. I do not see that happening. If any judge or any court is to look at her record, I think I said this before. this might be deja vu. I swear to God I said this before. She's not, it's no appeal is happening. Not on the grounds of like, oh, I didn't get a speedy trial because I didn't waive it. Somebody waived it for me. Therefore, I'm supposed to mistrial. Nah, fuck that. That's not going to happen. That's not going to happen. Are you fucking kidding me? You really think you must be stupid if you think that's going to happen, because any court's going to look at that and be like, dude, you had 8 lawyers. Brother, it took 5 years, 6 years or some shit at this point. Fuck no, that's not going to happen.
Delays by, constantly being unsatisfied. And every time there's a new lawyer, has to be another delay. And even in her last hearing, her surprise hearing, she's asking, well, will my time be
Her surprise hearing, quote unquote.
prorated? Like, because I didn't get my disclosure, do I get an extra so many weeks tacked on the end? So she's basically asking for a delay again.
Yep.
And here she's citing something that's talking about
She's
a
all
speedy
over the
trial.
place.
So she's quoting right to counsel is assured by the Sixth Amendment. She quotes the law dictionary here. And again, I will point out her right to counsel is not being denied. It has not been removed from her. Her right to court-appointed taxpayer-paid counsel was waived by her own conduct. And all of the reasons were set out in the judge's order on that. Waiver of counsel, I'm going to read this one to you. Waiver of counsel is a criminal defendant's refusal of counsel at any stage in the criminal process. I have never refused. I guess walking out on your lawyer doesn't count. It is made by a person with full capacity, unprepared, that is knowing and voluntary.
Bro, what she's talking about right now is Daryl Brooks. He knowingly and willingly waived his right to counsel. That's what she's talking about. Bro, there's different ways that you can waive your right to counsel. By conduct is one of those things, She's going to say these things probably a few more times, and then when she realizes she's not going anywhere, I think she'll back off. But come on, you're not stupid. Some people willingly and forthcomingly say, I want to waive my right. And then some people act like dickheads until they take away the right. Same. Still no lawyer.
And she's gotten brackets in capital letters forced. And that clearly and unequivocally rejects representation or assistance by an attorney at law during the pending proceedings. And she's quoting a waiver of counsel from the law dictionary. Here's the problem, Sarah. The law dictionary is one thing. It's informative. It's interesting. It's perhaps a nice starting off point to direct you where to look. But the judge has case law. There is more to the law than just something you found in a law dictionary. This doesn't cut it. And the forfeiture, the waiver of counsel that happened in this case is different, and it falls under different case law. And the law is that waiver of counsel can also be accomplished, I guess, because I can't think of the word, through conduct, which is what Sarah did. A defendant's decision to waive the right to counsel must not only be competent, but also knowing and voluntary. So again, this
Knowing and voluntary. That's like the perfect example of Daryl Brooks. It was knowing and voluntary. But again, she explained it to us. The judge can do what he wants under the right circumstances.
This is not the applicable portion of the law in this particular case. And if she's going to argue lack of competence, saying, I didn't know. Well, this is why the judge in his previous order set out all the times that she had been warned. Right to waive counsel, again, forced by the court, she writes in here. No, it wasn't forced. These are the consequences. You were warned. You were warned repeatedly. Is the right knowingly to proceed in ignorance. It is sufficient for purposes of both the state. This is all, okay. This is just, she's just quoting the law dictionary. Oh, sorry, she's quoting case law. It says the court must first make inquiry into his competence and be reasonably satisfied of it before accepting the accused's waiver of counsel. And she puts in brackets, never gave. Competence means more than a minimum of mental awareness and capability, however, and involves an intelligent conception of the consequences of his act. She puts in brackets, no one explained to me. Okay, let's parse this a little bit. This is talking about a situation in which a defendant says, I want to be my own lawyer and or I want to waive my right to counsel. And it's incumbent on the court to make sure that the defendant doing so is competent to do so. And competence means more than just knowing who the judge is. But the bar for that competence isn't super high. It's more than just an awareness, but it doesn't rise to the level of having some sort of legal expertise here. So is Sarah trying to vaguely make the argument that she wasn't competent to waive counsel? But she says here.
Yeah, she, after all these letters, page after page after page after page, there's no way in God's green earth that anybody would think that she's incompetent to stand trial. What? She's written so many letters. You would have to be crazy to think she was incompetent to stand trial. She might be dumb, but she's not incompetent.
Here, but she never gave that to vaguely make the argument that she wasn't competent to waive counsel. But she says here, but she never gave that waiver. But she did. She did so by her conduct. So is she suggesting I didn't understand that through my conduct that I would waive my right to counsel? Well, that's what it sounds like. And she says in brackets here, no one explained to me, except they did. They did. They may not have laid out all the nuts and bolts of how it would all come down, but she was warned repeatedly. She just quotes some more. I'm going to read this next section because I'm seeing that it's partly a definition, but she's got stuff in brackets here. So I'm going to.
This is why I refuse to read this shit. I was like, fuck that. I'm not reading that. The second I saw her video, I was like, fuck that. We're gonna mosey on over to this channel.
Read this. Ineffective counsel is both a standard of inadequate performance for a lawyer in a criminal representation and a failure of due process of law to the criminal defendant. A person who has suffered a punishment in a criminal proceeding, in brackets she writes, I was repeatedly lied about by former attorneys to the judge who is unjustly believing all over me, falsely accusing me of an inappropriate and wrong strategy of removing attorneys who withdraw from my request to the court for intervention, causing me to be forced into losing my right to counsel from their ineffective counsel. It has to be somebody else's fault. You see, they were all bad, and the judge was bad because the judge believed them. And because everybody was bad, then it looked bad on me. And so that I got punished somehow, like I lost my right to court-appointed counsel, none of whom, by the way, were nearly good enough anyway. So it's all your fault, Judge. It's all everybody else's fault. Everybody lies except for Sarah. That's what she wants you to believe. She's put strategy here in quotation marks. And I wonder if she is taking issue with the fact that people believe or suspect at least that this is a strategy on her part. And if in her mind, it wasn't a strategy to delay trial. This might be offensive to her. It may be true that people are misunderstanding at least part of her motivation here. I think that Sarah doesn't completely understand her motivation. Having said that, I think there is a part of her motivation that just comes from her personality, which is I need to have control.
Control.
You do everything I want, how I want it, when I want it. And by the way, if I decide to change the rules, you got to somehow figure that out.
Control. Yep. Damn. She got it. She understood. Damn. Yep. Nothing to say about that one.
And go with it. And people won't. And she doesn't deal well with that when they don't. She doesn't like it when people aren't puppets. So in her mind, she may be thinking, this isn't a strategy to get rid of all these lawyers. This is a strategy for them to do what they're supposed to do as I conceive of it. Not sure if that made sense.
No,
and then it goes
that makes a lot of
on
sense.
with the definition from the law dictionary and cites a case. And she cites the Florida Constitution, equality before the law, the right to enjoy and defend life, liberty, and to pursue happiness, freedom of speech and press. So every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that right. Did she read what she wrote? She wrote out the law here. Every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that right. Can we highlight this sentence and mail that back to her? I'm not actually asking. And here in this bit about free speech and a free press, it talks about defamation. If the matter charged as defamatory is true and was published with good motives.
There's not a single thing defamatory about this. Everything we're talking about is true as fuck. Defamation? What are you, the CEO of like Walt Disney or some shit, and we're trying to defame you? The fuck are you talking about? That you're a drunk from fucking Florida, big dog. I mean, you know what I mean? There's no defamation going on right now.
And she writes in brackets here, the defendant writing truthful, lawful letters to the court requesting help with dysfunctions of attorneys, then the defendant is unlawfully forced to forfeit her right to counsel from lies, misinterpretations, and ineffectiveness from those former attorneys, retaliation from the court. Ooh. And then the rest of the definition here is the party, and she puts defendant, shall be exonerated, and she puts in brackets, given appointed counsel. So she is making an argument here to be appointed another lawyer, basically. I don't think she understands standby counsel isn't going to give her what a court-appointed lawyer to handle her case would give her. And I find this interesting and a little bit ironic because she talks about defamation, yet she writes, knowing it will be published, that the judge is on the take. Do you remember that? Do you remember her asking, Your Honor, what's your cut? In one of those letters, she makes allegations of misconduct and in some cases, actual criminal offense against attorneys who are in a position where they're legally not allowed to stand up and defend themselves because of attorney-client privilege. She makes defamatory statements in almost every letter. I want to say every letter, but I can't remember them all clearly, so I could be wrong. In almost every letter, she makes defamatory statements knowing they will be published.
Come on. She knows her thing is highly televised. That's why she said, let's get this show on the road. She writes out of emotion because she can't control them. And that's why she writes so much, because she's steaming and just scribbling and writing. Because she need, like, again, the main thing she pointed out that's just like, I mean, it's not a revelation from God, but it's just so real. Sarah Boone needs that control. That control is everything for her. If she can't control the situation, she don't know. She's lost. You know what I mean? She's lost. She don't know what to do if she can't control. Yeah. And Jorge cheating on her, or George, as she would say, George cheating on her was not her in control, was her not being in control. When she would punch him and he would be like, bitch. And when he would punch her back, she wasn't in control no more. She didn't like that. She didn't like, because I know her ex-husband didn't treat her like a dude. She probably hit him too. And he would just be like, you know what? I'm divorcing you. Mature, sir. Very mature. Not everybody's that mature. You want to start boxing? Hey, some guys will start doing the little Mike Tyson bob and weave with you. I mean, don't play those types of games. I don't feel sorry for her. And everybody's like, "Oh, you don't hit a woman. You don't hit a woman." I wouldn't do it. I would just leave. But I mean, I'm not gonna be like, "Oh my God, he's a demon for hitting her, bro." She hit him. What are we talking about? What's the saying? Equal rights, equal fights, bro. You want to smack somebody across? Anyway, I'm just saying.
In fact, she has, on occasion, stated that she is intending to write to the world and to the public. Her intention was that these things be made public. So let's talk about defamation then, Sarah. But in her world, the rules and the laws only apply to her when they benefit her. Yep. When she actually has to comply with the laws and the rules, well, yeah, and then not so much. And her good motives that she claims to have published these things with, we know that's not true. And again, she wasn't forced to forfeit her right to counsel. She was forced to stop making you pay for her lawyers that she abuses and lies about and tries to force to do unethical things. And retaliation from the court. I want to address that. It is not retaliation. It is not punishment. Her waiver by conduct, the judge found this is waiver by conduct. This was not.
How much objection and grounds do you think she's going to do? Oh, it's going to be saucy. It's going to be spicy. You know, the thing is, I think she's going to shut the fuck up and respect Judge Kranick. But every once in a while, it's going to bubble up out of her. She's going to have an outer body experience and just have to say something. It's going to happen. Like Daryl Brooks, no. She's going to have a few moments, a few clip-worthy moments. I don't think it's going to be an ongoing circus. I really don't. Because in her head, she really thinks she could win this. Daryl Brooks knew he couldn't win that. Ronnie O'Neal knew he couldn't win that. They were fucked, so they just were wilding out. Treehouse Murderer, Ty Tucker. He knew he had a chance of winning. In Sarah's delusion, she thinks she has a chance of winning. So with that being said, she's going to stay within herself. She's going to stay as composed as she possibly can.
A sentence. This was a natural
AG Tactical, will you do the trial live with us, please, please, please? You know, like this is like my favorite trial this year, so I'm gonna do everything. I'm gonna make the videos. I'm gonna go live. I'm gonna fucking try to get the phone calls. I'm gonna get the paperwork. You know what I'm saying? We're gonna go all in as much as I can. Don't worry about that.
Consequence. She was warned. If you walk off the edge of the roof, you will hurt yourself. Don't do that. Stop doing this. And people tried to explain to her in different ways. Different people tried. This isn't effective. You have to understand what you can and can't expect. You have to understand that there are some things that a lawyer decides, not the client, and some things that you as the client get to decide, regardless of what your lawyer says. There are other clients that lawyers have. The world doesn't revolve around you. Nobody actually said that, but that's the gist of some of it. And she was warned. And she decided she was going to do what she wanted anyway, because that's what she does. Mr. Torres was saying, I can't breathe, and she was going to do what she wanted anyway. It's just that up until now, it's everybody else who suffered the consequences for her behavior. Now she has to suffer the consequences for her own behavior. But guess what? The court will probably give her standby counsel. Section 5, right to assemble.
Well, no. I just said they will. No, they won't. That was the hardcore thing about it. Hold on. Is it close by? Let me see if I have it. Let's take a little. Oh, I thought I had it close by. Hold on. Hold on. I have it somewhere. Give me a sec. Yep, it's open. Boom. Now, if I'm reading this right, I'm no, the smooth brain that I do have processes that this is saying. Hold on. Let me. I just made an indistinguishable noise for no reason. Okay, so this is what the smooth brain of AG Tactical is understanding. It says, as for the appointment of standby counsel, the court has entered an order on June 28th, 2024, finding that the defendant waived her right to court-appointed counsel through her conduct in this matter. Thus, the court has already ruled on this issue of appointed counsel. Cut, point blank, dry. So what I assumed and what she assumed is that they would give her standby counsel. But what I'm understanding from this here letter is that the judge said, nah, fuck you. You don't even get standby. None of that shit. He just said no. Like, as I said, bitch, you're not getting standby counsel. You're not getting none of that. Nothing. Nada. So that's crazy. I thought they would at least give him. A little side counsel. But what I'm understanding is no, not even that. You're by yourself, super by yourself.
What? The people shall have the right peaceably to assemble without harm, to instruct their representatives to petition for redress of any grievances. Why is she quoting right to assembly here? Is she trying to suggest she has the right to protest to the judge? Maybe that's what she means. Oh, this trial is going to be a headache.
It's going to be a doozy. It's not going to be a headache, sweetie. Man, listen, this trial is going to be amazing. A headache. It's going to be a headache for them. I'm going to be over here in my little cozies watching this shit. I'm going to be having a good old time.
9. Due process. No person shall be deprived of life, liberty, or property without due process of law, or be twice put in jeopardy for the same offense, or be compelled in any criminal matter to be a witness against oneself. Okay, well, she's not compelled to be a witness against herself. There's no double jeopardy issue here at this point. No person shall be deprived of life, liberty, or property without due process of law. Well, where was due process denied her? She wasn't wrongfully arrested. As far as I know, there was no illegal search or seizure. But you know what? You know who was deprived of his liberty? Mr. Torres.
Maybe Jorge.
The second he asked to get out of that suitcase and she didn't let him out or go get help and have somebody else let him out, but she didn't affect his release. The second she did that, she deprived him of his liberty. Oh.
And everybody's like, oh, nobody would get me in no suitcase. Nobody would get me. Why would he be in a suitcase? He's stupid. That's the drunkest shit I've ever heard. You know, like, oh, he got into a suitcase. He zipped himself into a suitcase. Remember, they're alcoholics, guys. They drink a lot. They do drunk shit. That's like the most common drunk shit I could think of. Like, hey, go inside that suitcase. You know, I feel like that's how it started. Because I was thinking about it. I was like, well, I mean, they were drunks. So Sarah was probably like, I bet you couldn't go in that suitcase. I don't know. It does sound kind of stupid when I say it out loud. Like, why would I get in? Like, my girlfriend tells me, theoretically, hey, get in that suitcase. And we're hammered, right? We just took back like 7 shots. Hammered. I would still be like, what? No, I don't want to get into the suitcase. I don't know. I don't know how that happened. I don't think we're ever gonna know how that interaction came about, but it is something to think about. But if we ever get Sarah's phone calls, we'll probably get that answer because I have a feeling that she can't help herself.
Yeah, and she deprived him of his very life. But she's going to complain that somehow there was no due process. And by the way, I am aware that these sections of the Constitution applies, it's in respect to what the state can do to a citizen. But she did deprive him of his life and liberty, and she had no right. Section 16, rights of accused. I'm going to scan this. It's just, again, she's regurgitating definitions here. She cites the 14th Amendment, talks about due process. Oh, this is interesting. So, due process of law requires ample notice to the accused and sufficient time to secure counsel and prepare for trial. Well, guess what? You were given notice. You had ample time to secure counsel, which you did. And you received counsel. You were given that repeatedly, and you abused that repeatedly. And so at some point, honey, something's got to give. She has learned nothing. So in citing this, needing time, a reasonable opportunity to prepare for a defense, is she somehow suggesting that she should be given another delay? Because earlier she's citing sections related to the right to a speedy trial, which is, there's a whole section here. It's quoting case law, and it's all about opportunity to prepare for your day in court, getting enough time, getting reasonable notice to prepare. She can't argue.
I don't believe this one started out of truly playful, even as drunken play. I can hope they had some fun there first, but it doesn't sound like it. I think she disguised it as fun, and then it quickly turned into not fun. But I think she was trying to punish him, like a gotcha moment. Now I can talk to you, and I can vent because you never listened to me any other way. So now I have you trapped, and now you're kind of scared. So even if you're scared for your life a little bit, now you're scared for your life, and now you're gonna listen to me. And now what? I have control. Boom! Oh my God! Big brain moment. It all goes back to control. And now I have control over you. Now I have things just how I like them. I wholeheartedly don't think she was trying to kill him. Now, the whole baseball bat, I don't know about that. We'll see what that's all about. I have no idea what that's all about. But I really don't think she was trying to kill him. She wanted her control. She finally got her control when she got his dumb ass to go into the suitcase. And she went too far. But who knows?
That she's not got a speedy trial, and in the same breath argue that she hasn't had enough time. I mean, do you want to delay or do you want to go ahead? She's going to throw everything but the kitchen sink, or maybe including the kitchen sink, at this and hope something sticks. And this is all about the right to counsel. And again, her right to counsel is not being denied her. She can hire a lawyer if she wants. She has all these fans. Apparently, she said they would raise bond for her. She told the judge, you could set the bond, doesn't matter how high, because my fans will get the money for me. Well, hire a lawyer. I don't think she really does have the kind of fan base that would raise that kind of money for her.
She has bums who don't have any fucking money, bro. What are you talking about? Her fan base, a Sarah Boone fan base, consists of drunken moms alcoholic moms who have similar problems. It consists of trash, basically. Anybody, like, who's supporting this lady? You think the supporters of hers are going to have money to spare? Do you think an average Sarah Boone supporter has $20 to spare? And I'm not saying nothing about not having $20 to spare. I'm just saying the average Sarah Boone fan is probably homeless. Just saying. Probably teetering on homelessness.
I mean, who knows? But the bottom line is she has not been denied her right to counsel. She's been denied the right to the taxpayers' money to pay for that counsel because she repeatedly abused it. So I'm scrolling past a lot of this because it's just stuff that's copied out of the law dictionary, but I'm looking for anything where she's added something or that connects to something that she's argued about before. It's too bad that she didn't look up. I'm reading a line here. The necessity of counsel was so vital and imperative. this is something that she's regurgitating here. It's too bad she didn't look at this and recognize it beforehand. Yeah, I'm not going to read all of this to you. The words are up here. I mean, if you want to go back and pause and read it all.
She's like, the words are up here. Listen, when I started seeing this shit, the H and the G and the letters, I was like, oh God, she went crazy with it. She went full lawyer on us. That's the first thing I said. I was like, damn, she went full lawyer mode. And it's probably some incoherent, fucked up mumbo jumbo lawyer mode at that, at best.
You can. Federal Rules of Criminal Procedure, Section 44, right to and appointment of counsel. A, right to appointed. A defendant who is unable to obtain counsel is entitled to have counsel appointed to represent the defendant at every stage of the proceeding from initial appearance through appeal unless the defendant waives this right. And then in brackets, she has, defendant has been forced to forfeit her right to counsel from one-sided lies and unquestioned misinterpreted requests for understanding, intervention for remedy, not removal from the defendant to the court in her criminal case. In some of these cases, or some of these instances with previous counsel with her, she did say, well, I don't want him removed. I don't want him to leave. And then would finally say, yeah, I want to get rid of him. I'm thinking of Bankowitz here. One of the reasons that somebody like her is so frustrating to deal with is because she'll say one thing. Oh, no. I like you. I want you around. Then she'll mentally...
It's because she tries to mind fuck you. That's the whole thing with Sarah. It's everything for her is to control you. It's disgusting. That's why she's going to be alone forever. Maybe she'll probably get a girlfriend she could control in jail. I take that back. She'll find a girlfriend. She already seemed like she was kind of into girls. When the police came to her house one time, there was this female cop. It's not when she killed Jorge. It was when they were arguing. And she was like, hey, baby, how you doing, sweetie? I'll do anything. I'll do anything for you, baby. I don't know if you remember that video, but Sarah was quite flirty with the female cop. So I'm pretty sure she'll find herself a good little girlfriend to fuck with in jail. So South Korea are not helping then? What's up, Sion? But who's giving her money to buy all this paper? I don't know. I'm sure somebody's giving her money. Someone always is. And remember, think about Paul Ferguson and Shonda Vander Ark. If we didn't get those phone calls between him and Randy, him and JoJo, we wouldn't have really known where he was getting all that money from. We could just assume. When these phone calls drop, who knows who's talking to Sarah? She might have a whole boyfriend outside of jail. She might have a whole family supporting her. Who knows? The bets are off. So her affording paper, she probably got that off of somebody. She's probably married to somebody or some shit. Who fucking knows? So, you know what I'm saying? I'm pretty sure that's what's happening. I'm like so sure that I'll put a 70% on that. If we get these phone calls and we start breaking them down, I have a 70% chance that she's getting money from some lover.
Beat you down and make life so miserable and make everything impossible. And then when you complain, no.
Her ex even put money on her first two attorneys he tried. Poor guy. Disown her. I would have been disowned her ass. What are you talking about? Disown immediately. As soon as possible. Do not associate with.
Oh, I don't want you to leave. I just want you to do everything I say. I just want you to be my puppet. And when you're not being my puppet, I want you to be my punching bag. If you reject me, then I'll reject you back. If I think I'm not going to get everything I want out of you, I will ultimately discard you. She wasn't forced to forfeit her right. She chose to, but she cannot take responsibility for anything. More quoting legal stuff. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to the Honorable Court to provide immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. The defendant is requesting collaboration, oh boy, correct understanding and overall perspective of and in her extraordinary circumstances by rendering her cognitive incapacities, procedural inabilities, and extremely limited capabilities altogether as fact and concluding a remedy of assistance is rightfully needed to be provided to the defendant by the court. It is one thing to ask for standby counsel. I think that she should have some standby counsel. That's one thing. But she is not just asking for standby counsel. She has veered away here from the standard request. She's requesting also collaboration. Where have we heard this before? Like in every letter? Collaboration. Correct understanding. Correct. Meaning you accept my worldview. You accept my fantasy. Let me impose this on you. You adopt this. That's correct understanding for her. So correct understanding and overall perspective of and in her extraordinary circumstances. So she wants the standby counsel, but they have to meet these requirements.
They have to collaborate with her, which is crazy.
Or she's going to start complaining about the judges throwing darts in the dark again, right? It's the same thing. Same crap. Different puppy. Actually, it's the same crap, same puppy. Appointment of vital standby counsel will lessen greatly her probabilities of further loss, damage, spoliation, and oppression in her criminal case. Fair and equal position by fair and equal opportunity also will be greatly enhanced. The defendant's requests are in good faith, and her merits are worthy in striving to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of pro se attorney and her representation of self. If I address it again, I will be like a broken record if I'm not already. Okay, conclusion. So basically, give me what I want, please. The oath. Oh, interesting. Hang on a second. Hang on.
She's like,
because now this is a motion. This is not simply a letter. It's under oath. The defendant makes the following oath.
Do I need to help her again? What does that mean? Gosh, no wonder George was drunk. He probably climbed in the suitcase to get away from her mouth. No, I'm telling you, she got him to do that because they were fucked up in the first place. I'm telling you, man. Alicia Nelson, man. Shout you out, Alicia. Thank you so much.
Oath under the penalties of perjury. I declare under penalties of perjury that I have read the foregoing document and the facts and matters stated are true. She does say in this document that counsel lied to the judge. She made an allegation now under oath stating that counsel lied to the judge. This isn't just a letter and her beacon off. She's under oath now. And she knows she's under oath. She knows she has a responsibility to tell the truth. Yet she made those serious allegations in this document under oath. Will that come
said,
to...
What about August 3? All my August people. You're funny at Jim.
Anything? Will there be any consequence to her? I don't think so. But it tells you what the oath means to her. If she's willing to lie in a document, lie under oath. I mean, she lied to the police, but here she's done it again. She swore to the police that what she said was true, and she did that on more than one occasion. So her statement at the police station and also in her statement to the detectives in the car, that car interview, the hide and seek and all of this. She lied to them during that and did so under oath, swore an oath that everything she said was true. And here she's under oath again. So if she says anything in court under oath, it doesn't mean anything. You can't rely on anything she says to be the truth. That is it for that motion. And now there's a bunch more, but this will be faster. Temporary motion for reservation of proposed court costs.
Whoa, temporary motion for reservation of proposed costs to acquire investigator. So she's trying to acquire an investigator. They already have that covered. So they gave her the investigator, the prison break investigations or whatever goofy ass name. So that's covered. So half of these things, like I said, are investigator to be determined. That's hilarious. Total amount required to be determined. This lady is she really is batshit crazy. That's the definition. She's not mentally, what's the word? She's not mentally deficient. She's just batshit crazy. There's a difference. There's definitely a difference. I definitely see it. What's up, Jean Marie? Hey, Jean, everyone finally caught alive after a long time. That's what I'm talking about. Welcome in.
To acquire investigator for defendant's defense in trial. Sarah Boone, pro se indigent defendant, respectfully requests from this court the reservation of proposed costs to acquire investigator for defendant's defense in trial. Investigator to be determined. What? Really? She has an investigator. Does she not like him? This was written after the hearing that you saw where Billy Lane was present and he was...
You said her writing is appalling. I used to think it was ass, but now that I've gotten used to it, I could kind of just read it now. I'm not sure. At this point, it doesn't look bad to me because I've been reading her letters for a while. So I can kind of read it, but like I still have to do like offline videos so it's more smooth because sometimes I'll mess it up. Her M's in particular are really atrocious. They look kind of like H's. It's weird. Where's the M that I could point out? I'm gonna look for an M right now just to show you how they look. Pro se, indigent, defendant, respectfully. Where's the M? Oh, this M looks normal. From, where's another M? Investigator. Materials. That's a capital M. I'm talking about her lowercase m's. Motion being studied. What does that say? Is being studied or settled? Oh, see here, to meet. Look at this M. Doesn't that look like a Hreet? Like Hreet? Doesn't that look like Hreet to you? Like this would fuck me up. When I would read her letters and she would put M's on top of things, I would think it's like HR. And I'm like, what the fuck? What is she? What? Like my brain would start fucking breaking, dude. It was tough. One time I stayed up like super fucking late trying to read her bullshit letters. Had me fucked up. Had me all the way fucked up. But I learned her handwriting, so now I'm kind of used to it.
Tasked.
No, I know it's meat, but I thought that was a HR. Now I know what her M's look like, but that shit looks crazy to me.
With putting all her disclosure on USB drives. So why is the investigator to be determined? Does she want a different investigator? Is that what's going on here? I don't know. Total amount
could
requesting.
Be cursive and print together. And to be honest, I don't even blame her because sometimes when I try to write cursive, I don't even like my brain. I've been writing in print so long.
How to calculate unknown by defendant. Well, fair enough. She doesn't know. She cites her reason is that she has no discovery or case materials. Well, she will have. So we got to remember she wrote this prior to, well, she still hasn't received it. But as of today, that the day I'm reading this is July 30th. The defendant is trying to avoid any further persecution and penalization from the judge in court while vigorously attempting to succeed in her forced position of pro se attorney and representation of self. The exceeded time limit of
You're funny, Graciela. You're funny. Shit, go smoke a joint instead. Go get some ganja or some shit.
To receive the defendant's discovery and case materials promised by the court has forced the submittal of this temporary motion. Once the defendant has finally received, she will be able to proceed, will revise, and resubmit this motion upon completion of her review and research of the contents. Okay, earlier in the previous document, she brought up or she cited sections related to competency and how competency has to be more than a mere awareness. And this paragraph here tells me something.
That's how you learned it too, right? Exactly, Jacqueline, right? Exact 3 humps. I mean, isn't that the only way? Maybe there's different ways, but I don't know.
It shows us something, and that is that she is clever. So she was smart enough to figure out, okay, I've got a deadline for submitting these motions. I don't even know what motions I need to make because I don't have all of my discovery. So maybe there's something in there that would make me think, gee, I need to make a motion about this, that, or the other thing, but I don't know it because I haven't seen my discovery, right? You could see that argument. So instead of sitting back and saying, okay, well, I don't know and it's not my fault, she actually makes a motion and she's requesting this investigator. And she says, I will need to then revise once I've reviewed this. And that, fair enough, actually. But it shows that she has the wherewithal to think of that. She has the wherewithal to strategize. She's not completely blindly going about everything, just sort of flailing around, even though sometimes it looks like that. She does plan. I don't think there is any question about her competence. I also note here, she has to stick in there that I was forced every chance she gets. And I imagine that interpersonal conversations with her outside of all of this would be very similar. You ever talk to somebody like that who they just have to get a dig in every chance they get? If you were late one time 10 years ago, they bring it up every other conversation for 10 years. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to the Honorable Court to reserve any and all costs proposed to be incurred to acquire investigator for and in the defense of her criminal case for trial. The defendant's requests are in good faith. She could really make use of an investigator. And again, she adds forced. So, and again, she writes the oath. She handwrites the certificate of service. That's got to be time consuming. You know, when we do paperwork, a lot of time you're cutting and pasting, or you have forms that are pretty much pre-filled out and there are just certain sections that you go and fill in. So you don't have to rewrite all this stuff every time. She has to write it all out. Now, here's another one. Temporary motion for reservation of proposed costs to acquire expert witnesses for defendant's defense in trial. Bankowitz had for her, who was prepared to go ahead, and he had a heck of a time apparently getting anyone to even agree to it. And he said it was because of the cost, that the experts that he had in mind wanted more money. So he was chasing after more money for that. But then Winston Hobson managed to find another expert willing to take the case for the amount of money that the system allows for. So he didn't have to go chasing any extra money. So I don't know if any of those experts spoke with Sarah or already reviewed the file, because in that case, that would lower the costs, yeah? And that would save some time. So if one of these experts could get on board, the one she's already spoken with.
You bet Simone could escape the suitcase.
That could be helpful, but I don't know if she's going to be going after a different type of experts, because what I gleaned from previous discussions was that she didn't want to go with battered spouse.
Have a great day, Tom.
That wasn't the path she wanted to take. Do you remember that? So I don't know if that's the kind of experts she wants or if she's looking for different experts. And she doesn't know how much she's requesting. Fair enough, she wouldn't know. And she doesn't know how to calculate it. And again, she cites her reason as no discovery or case materials. I think that's not the reason. I think the reason is because I need an expert witness, because there are some dynamics here or some science here that requires expert analysis or expert explanation to a jury. So the reason, therefore, should not be that she doesn't have discovery. That should not be the reason. But she's putting that here because she's ticked off. I want what I want when I want it. And fair enough, she should have her discovery, but that's not the reason for the expert. And again, she includes this paragraph. The defendant is trying to avoid any further persecution.
I said it before, though. I don't agree with the judge when he's told her that the trial is just going to continue at the pace that it's going. Because if she wasn't allowed her discovery for that long, and then, you know what I'm saying, you lose those weeks, even if it was your fault, you're being a bitch. Everybody hates you. You lost your lawyer. Okay, you have to do it yourself. Even if you're being a bitch, I think you should still have the right to have the amount of time to at least have to pregame. Like, okay, it would have been 3 weeks, theoretically, right? It would have been 3 weeks of preparation, maybe a month and a half of preparation, and then it got cut down to like 3 weeks. So let's say it was a month and a half. Theoretically, it got cut down to 3 weeks. I would give her those extra 3 weeks. I mean, those extra couple weeks, you know? But I guess the judge doesn't see it that way. So, you know, boo-hoo for her. But just to avoid any problems later on, I would give her that extra time. How far in life would she have been probably, if she was able to achieve her intellectual? Yeah, I don't know. Probably pretty far. But she is kind of a dumbass at the same time, so.
And penalization from the judge in court while vigorously attempting to succeed in her forced position of pro se attorney and representation of self.
No extra time. Shit, she's had years. That's true.
And again, the whole section on the exceeded time limit of waiting to receive the defendant's discovery and case materials promised.
And then that's what everybody's going to say. She had 5 years. So, you know. But then she's going to say, but I didn't have control over my case until 2024. And then when I asked for more time, he didn't give it to me. And I was unprepared, and I got absolutely fucking destroyed in 2 days and went to jail immediately, and now I'm filing for an appeal. That's what I'm thinking she would say. I don't know if this is going to work, but that's what she's going to say. But hey, maybe she's going to file it no matter what, so just time to go on with the program at this point.
By the court has forced the submittal of this temporary motion, and she will revise and resubmit upon completion of the review of the contents, and the rest is pretty standard. She makes her oath, certificate of service. Here's the next one. Temporary motion for reservation of proposed cost to acquire all witnesses for defendant's defense in trial. Wonder who she's going to call. Wonder if she's going to try and call Brian. Who do you think she would call? Who, in your opinion, would be witnesses to defend her? Comes now, Sarah.
She's going to call her ex-husband. She's probably going to call a friend for character. Those are 2 people. I don't know. Definitely her ex-husband in the blue shirt, that guy. Yeah.
Boone, pro se indigent defendant, respectfully requests from this court the reservation of proposed costs to acquire all witnesses needed for the defendant's defense in trial. Witnesses to be determined. Total amount to be determined. How to calculate, unknown. Reason, no discovery or case materials. Okay, that's not the reason you get witnesses. That's not the reason you're asking for costs that you're going to have to incur to get subpoenas or do depositions or anything like that. On the prosecution side, they know where all the witnesses are, or they should, right? I don't know if she's going to be calling some other witness. So she may have to track somebody down, in which case she can use an investigator. But the point is here, the reason for asking for the costs to accomplish all this is not that she doesn't have discovery. That's not the reason. She just has to stick that in there. I don't have my discovery. She's like a broken record. You didn't give me notice. Am I getting a certificate of service? And it's the same stuff. It's an exact copy of the final paragraphs as in the last two, I think we've read. And the conclusion and oath, her certificate of service, temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court. She wants depositions to be conducted, deponents to be determined. And fair enough, she can't actually know that until she looks at all her discovery, because some of them may have already been deposed. I know that Cashman did do some depositions. I saw that. Scheduled dates for depositions to be determined, total amount requested to be determined, and she's going to want transcripts, and that's to be determined. And reason, defendant has been forced into the title and position of pro se attorney by the judge in court. Pro se attorney
She's so mad about that. She brought that up like 4 times already. Jesus. Like, we get it. You've been quote unquote forced. Sorry, but that's what's happening.
Request to take depositions for her defense. And so this falls under reasons no discovery or case materials have been provided. Well, no, that is not the reason for this. You just got to stick that in there. The reason is partly that, yeah, I have to do it myself, and partly because I probably need to make sure all the witness depositions have been done, and I'm covering my bases because I don't know if they have been done. And then she cites the rules of criminal procedure, and I note, and I hope she's read this herself. In any case, this is from the rules of criminal procedure. In any case, no person shall be deposed more than once, except by consent of the parties or by order of the court issued on good cause shown. So, if somebody has already been deposed by the defense, whether that be by a Cashman or Bankowitz or another lawyer, remember the first lawyer, he was ready to go to trial. That first lawyer, that private lawyer, was 2 weeks before trial. So a lot of this may have already been done, and she may not need to do any depositions. They may have already all been done. And Cashman, it appears, went through the file and saw a couple that did need to be done that weren't done. So she did those. There may not be.
Yeah, she's fully loaded. And my theory was that she wanted the lawyers to do everything for her, piece by piece, and then go to trial for herself because she didn't have the tools. So she would just let the lawyers do it, fire them, let the lawyer do it, fire them, let the lawyer do it, fire them, and then go to trial for herself. And I mean, it kind of, I don't know if that was her plan, but it's definitely going in that direction. All the depositions got done. Do you think she was going to be able to do that? No. You know, all the tedious shit got completed.
Much to do unless she decides that somebody ought to be a witness who hasn't already been identified or tagged as a witness by the prosecution or by previous defense counsel. So the defendant may take the deposition of any witness listed by the prosecutor as a category A witness. The defendant may take the deposition of any unlisted witness who may have information relevant to the offense charged, which is appropriate, but oh boy, in Sarah's hands, I wonder what she's going to go for. Oh, look at this. It looks like she's asking for sanctions. She's not stating this here. She's citing something here. And she has been setting up for this for a long time. I haven't seen my discovery.
Have a great day, Carol.
I don't have all my discovery. She would never name what it was. I know that the world has seen discovery that I haven't seen. And I'd say in previous videos, well, okay, if you know what that is, then tell us. Everybody's seen it. You're describing it. Well, what is it? Tell us. I mean, obviously you know about it. And I think that she has been making this sort of vague, nobody showed me, despite it having her handwritten notes on it. Nobody showed me. And it's all a setup to complain later. Well, I never got it. And here we are. If at any time during the course of the proceedings it is brought to the attention of the court that a party has failed to comply with an applicable discovery rule or with an order issued pursuant to an applicable discovery rule, the court may order the party to comply with the discovery or inspection of materials not previously disclosed or produced, grant a continuance, grant a mistrial, prohibit the party from calling a witness not disclosed or introducing in evidence the material not disclosed, or enter such other or as it deems just under the circumstances. This is a responsibility on the state. If her lawyer gets all the disclosure in a timely or appropriate manner, and for whatever reason didn't let Sarah read every single page of it, maybe he or she simply told her about it or explained it to her instead of letting her leaf through every page, well, that's not on the state, right? Under the law, the defense still got the disclosure. The fact that she didn't hold the piece of paper in her hand doesn't mean that the defense didn't get the disclosure. It doesn't mean that the prosecution violated any rule of disclosure. Now, if there is something outstanding that Sarah knows about and is expecting and hasn't seen, and maybe that's what's been going on. I don't know. If there is something outstanding that the prosecution hasn't turned over, if there's a violation of a rule, well, then that's another thing. But she's not actually alleging that. And if she was going to allege that, she would have to be specific about which thing and when. When did the prosecution have this and not disclose it? The fact that her lawyer didn't let her hold a piece of paper in her hand is not the state's failure to provide disclosure. And she's just quoting law and the same closing paragraphs. Her conclusion, oath, certificate of service, and my goodness, that's it. There you go. Sarah's motions.
She was like, and my goodness, that's it. Yeah, that was some reading for you, wasn't it? Shit. Sarah Boone, ladies and gentlemen, Sarah Boone, coming in hot, coming in strong. But this is gonna be interesting, folks. This is gonna be fun. This is gonna be quite fun. This is gonna be fun as shit.